Tonight, another twist in the trial of Oscar Pistorius as the judge orders the athlete to undergo psychiatric tests.
If it appears that due to mental illness or mental defect, the accused might not be criminally responsible, then a referral is in order.
It's brought the trial to a temporary halt and could have a major bearing on the outcome.
A proper inquiry would ensure that the accused gets a fair trial.
Good evening from the Oscar Pistorius murder trial here in Pretoria. In a surprise move, Judge Masipa has suspended the trial and ordered the athlete to undergo an evaluation for mental illness. Despite objections from his defence team, the judge wants to know if Pistorius has a condition that might diminish his criminal responsibility. Pistorius is accused of murdering his girlfriend Riva Steenkamp on Valentine's Day last year. Judge Masipa says her decision is in the interests of a fair trial. Well, the drama began this morning even before the court TV cameras were switched on. The athlete was made to wait as last-minute negotiations took place before the judge arrived to deliver her ruling.
The state has launched an application for a referral of the accused. Strangely, the application is opposed on behalf of the accused. If it is alleged at criminal proceedings that the accused is by reason of mental illness or mental defect or for any other reason not criminally responsible for the offence charged, or if it appears to the court at criminal proceedings that the accused might, for such a reason, not be so responsible, the court shall, in the case of an allegation or appearance of mental illness or mental defect, and may, in any other case, direct that the matter be inquired into and be reported on in accordance with the provisions of Section 79, close quote. It is clear from the wording of the section that the key words are, if it is alleged or if it appears that due to mental illness or mental defect, the accused might not be criminally responsible, then a referral is in order. The trigger to the application was the evidence of Dr. Merrill Foster, a forensic psychiatrist, called on behalf of the accused. Counsel for the state submitted that it was clear that the evidence of Dr. Foster that the accused suffered from a generalized anxiety disorder at this stage of the proceedings was calculated to make up for the accused's bad performance as a witness. He submitted that the fact of the evidence of Dr. Foster may become important should the court reject the evidence of the accused, hence the application for referral. In opposing the application, counsel for the defense submitted that there was no allegation as envisaged in the act, or if there was, it was not substantiated. He submitted further that it did not appear that at the time of the incident, the accused was not criminally responsible. For these reasons, he argued the application could not succeed. The accused may not have raised the issue that he was not criminally responsible at the time of the incident in so many words, but evidence laid on his behalf clearly raises the issue and therefore cannot be ignored. Not only that, but the allegations have been properly substantiated by the evidence of Dr. Foster. Dr. Foster compiled a comprehensive report detailing the accused's developmental history, which included social and professional relationships and how they shaped his personality. She also dealt with past medical history, past psychiatric history, habits, history of the incident, mental state evaluation, and psychiatric diagnosis. Her focus was on her diagnosis and her findings that the accused suffered from a generalized anxiety disorder which may have affected his conduct on the 14th February 2013. She repeated this under oath. To fully understand the significance of Dr. Foster's evidence, it is necessary to focus on extracts which I think are of some relevance. Dr. Foster mentioned, for example, that the accused, amongst other things, was hypervigilant. When asked what she meant by that, she stated, I quote, "Hypervigilance is somebody that is over-vigilant, so they're constantly looking around, scanning their surroundings for any kind of threat and generally not able to relax," close quote. Counsel for the defense asked, any relevance in the physical vulnerability in relation to his anxiety? Dr. Foster's response was, I quote, "I think they go hand in hand, my lady. His physical vulnerability makes him more anxious. His anxiety makes him want to conceal his physical vulnerability," close quote. Dr. Foster stated more than once that the accused has a long history of generalized anxiety disorder that appears to have been increasing with time. She set out a number of factors which were responsible for increased level of anxiety and then stated the following, I quote, "These factors were all operating at the time of the offense under discussion and would have been compounded by Mr. Pistorius' physical vulnerability and the additional pressure of perceiving his environment as hostile and unsafe. When exposed to a threat, Mr. Pistorius is more likely to respond with a fight response rather than a flight response, as his physical capacity for fight is limited," close quote. Explaining what was meant by a fight or flight response, Dr. Foster said, I quote, "This is a response that protects us and helps us to keep us safe. So when exposed to a threat, we can either fight or flight, depending on our own personal circumstances. And in Mr. Pistorius' instance, he would have been more likely to fight as his capacity to flight was compromised. In my opinion, Mr. Pistorius' reaction to the perceived threat during the incident of 14 February 2013 should be considered in the light of his physical vulnerability and his comorbid diagnosis of generalized anxiety disorder," close quote. Although Dr. Foster stated that she did not think that a generalized anxiety disorder was a mental illness, for purposes of the Act, she stated the following, I quote, "I think it is clear that Mr. Pistorius has a psychiatric illness. He certainly was able to appreciate the difference between right and wrong, but it may be that his ability to act in accordance with such appreciation was affected by this generalized anxiety disorder. Mental illness and mental defect are morbid disorders that are not capable of being diagnosed by a lay court without the guidance of expert psychiatric evidence. In the present case, Dr. Foster's evidence was placed before court by the defense. The effect of the evidence is that a doubt has been created that the accused may possibly have another defense relating to his criminal responsibility. There is also a possibility that there may be diminished criminal responsibility. The evidence of Dr. Foster has not been contradicted, nor can it be in the absence of other psychiatric evidence. This court, as a lay court, is ill-equipped to deal with the issue raised in Dr. Foster's evidence at this stage. The allegations in the report of Dr. Foster and the views expressed by her have substance, and what is more, they are in line with the accused evidence. That in itself is significant. Dr. Foster's report, however inclusive it may be, cannot replace a proper inquiry made in terms of the Act. Among other things, Dr. Foster had only 2 interviews. During the interviews with the accused, the duration of the interviews with the accused is not stated, while it appears that she may have had very little time in which to compile her report. A proper inquiry, which would be more comprehensive, would, inter alia, in my view, ensure that the accused gets a fair trial.
Well, by now it was clear Oscar Pistorius would be sent for assessment. The judge then explained why her decision was about whether justice has been served.
The question is whether there was a reasonable possibility that a referral of the accused for observation in terms of Section 79 of Act 51 of 1977 would reveal inter alia that at the time the crime was committed, the accused suffered from a mental disorder which could have resulted in his not being criminally responsible for his act. Having regard to the facts of this case, I'm persuaded that the requirement of a reasonable possibility has been met. It is so, as counsel for the state submitted during argument, that a referral inevitably means more delays in finalizing this matter. But this is not about anyone's convenience, but rather about whether justice has been served. It is necessary to emphasize that an application of this nature is never taken lightly, as it is an integral part of a fair trial. Having regard to the above, I am satisfied that a case has been made out for the application or the relief as sought by the state, and I shall grant that order. However, the specific order itself will be handed down on Tuesday next week.
As the court pleases.
As the court pleases, my lady.
Before I adjourn, is there anything that counsel might want to?
My lady, we have agreed between myself and Mr. Roux that we will assist the court in preparing the order and that we will have the order available and ready by Tuesday morning. We will meet and assure the court that we agree on the specific order and that it could be made on Tuesday. There are various administrative issues that need to be considered and dealt with in this time, but we will have enough time, my lady, to deal with all those.
Thank you. Mr. Roux?
That is indeed correct, my lady. We undertook, because we know about the time delays in the event of a detention that we have discussed, the so-called outpatient basis in the Volkman case. I don't anticipate any difficulties on that, but we will prepare a proper order for the court's consideration, and also what we believe should be on the panel, like also not only 3 psychiatrists but possibly also psychologists,
as well.
but that's in the hands of the court. But we will make recommendations to the court and in our draft for the court then to consider and accept or amend.
Thank you very much.
Thank you, my lady.
Yes, I just want to place on record that it is, I'm glad counsel agreed on this. I think it should be borne in mind that the aim of referral is not to punish the accused twice. So if there is a possibility of making sure that he's an outpatient, I think that would be preferable.
It will be investigated.
Yes. Thank you very much. We'll adjourn until Tuesday. What's the date?
20th of May, Malay.
20th of May.
Yes.
At 9:30 in the morning.
As it pleases.
To discuss it all, I'm joined by legal expert Martin Hurd and clinical psychologist Franco Fisser. Thanks for joining us both. Now, first of all, Martin, the defence never wanted this. So how have we ended up in this situation?
The consensus among the legal community was that the referral would not be made. That changed last night when people had time to do a little bit of research and look at what the law said. And the consensus amongst the legal community was that this was unanticipated by the defence. They put a witness into the witness box who opened a door that they had not contemplated, and we've gone down a route now that was completely unanticipated. But I might add, in the light of the judge's very well-reasoned decision, it seems to be the right thing in the circumstances, but I'm sure Franco is going to confirm that. It seems to be the right thing in the circumstances to inquire into the mental health of Pistorius, because we don't want it to become an appealable issue.
Franco, we know that the court is coming back on Tuesday to discuss the details, but what happens now? He's going to be assessed for 30 days. What's the process?
Well, it's a very technical and drawn-out process from here, unfortunately. They have to probably compile what they call a panel of inquiry, the hospital itself, for purposes of this observation process. Each panel member has their individual interview, and also if a clinical psychologist sits in, they have their own individual interview, they have their own assessments that they will redo. So you have individual interviews, you have interviews together with your panel members. The basic question, and there's a basic formula going to this, is that they get the history as far as they can from his developmental history as he's grown up, when his amputations happened, etc., etc. So background history, and then they go into specific detail as to the night of the alleged offence, when Ms. Steenkamp was killed. So, and that basic questioning will be repeated in the days that he goes for observation. They will every time ask him, what happened on the day? Please tell us what happened on the day. So they can check if there's consistencies in the version, they can check for psychiatric or psychological symptoms. So it's a repetitive process that happens from then on.
If I can add, the rules of our High Court in Pretoria then require that the experts prepare what's called a joint minute. They have to sit down together, they have to note what they agree upon between the three of them, and then what they disagree upon. And in certain circumstances, if the parties or one of the experts completely disagrees with one of the other experts, they then have to prepare a separate report which is submitted as a dissenting report effectively.
Well, we're clearly talking about a considerable amount of time, 30 days for the assessment, then the report has to be compiled, and then there's a possible debate about the content of the report. But once it gets into court, what will the lawyers be looking for? What will the judge be looking for? What is going to be significant about it?
We have to look at three different scenarios. The first is that there's nothing wrong with him, in which event the trial will proceed, the court will make a decision, and there will be consequences that flow from that decision. The second is that there is what the legislation calls a mental defect. It's archaic technology, but it means that he has some sort of psychological problem. If that is the case, then the experts have to give a recommendation as to whether he has no capacity to understand his actions or whether he has diminished capacity. If he has no capacity, the trial will stop. It will not proceed because they cannot convict him. The court can't convict somebody who has no capacity to understand the wrongfulness of their actions. If he has diminished capacity, that will be taken into account when it comes to sentencing in the event that he is convicted.
Or they can just, if there's diminished capacity for some other reason, because they do comment on fitness and responsibility, criminal fitness and responsibility in the report, that they can decide that at this moment Mr. Pistorius might need treatment first before the court case continues. In-depth psychiatric treatment, which is also an option.
Yes.
So what will be a good outcome for the prosecution or a good outcome for the defence? Is it possible to say?
We need to know, does he suffer from some illness that prevents him from being held responsible? Is it a ruse? Is his behaviour not significant enough to let him raise the defence of no capacity or diminished capacity? So what's important is that the experts will prepare a report to say we can carry on, we cannot carry on, or there should be treatment as Franco indicated. So it doesn't matter what the outcome is. It deals with the issue so that it gives guidance to the court which direction that they can go in, and they have to go in, and it also eliminates the possibility at a point in the future that his capacity becomes an issue for an appeal.
And how much can the report be relied on by either side? Can it be disputed by either side, Martin?
Well, first of all, if you recall what the judge said, she said very specifically, this is a lay court, meaning I'm not an expert, I'm not a psychologist, I'm not a psychiatrist. I have to be guided by what the experts say, which means if all the experts agree on what the diagnosis is, there is no issue. She accepts the joint minute. She says the 3 experts agree. No problem, I will act in accordance with what they say. If there is any dissenting opinion, then she has a discretion. She could refer for further treatment. She could ask for further expert reports, or she could say, I'm accepting the majority view.
So what is the process going to be like for Pistorius? He turns up every day for 30 days, assuming he's an outpatient. How arduous is it going to be for him?
It's a basic interview format. It's a basic format where he has to retell the events that occurred on the night. So it's not something that will totally drain him like the court case is at present. It's just the journey to and fro from wherever they will do the observation. But I wanted to add to what Martin said. In terms of the report, if they bring out the joint report and there is some or other unhappiness from either side, the state or the defense on the report, they can of course lead the experts who compiled that report, lead their testimony. The judge can, or the state or defense can require those people to come and give testimony in court, which is a whole new set of experts being introduced in a prolonged case already.
Okay, thank you very much for your expert opinion on this. So certainly another dramatic day in court, and one that surprised many. Remember, there's a special catch-up programme this weekend, and we'll be back on Tuesday to hear exactly what happens next to Oscar Pistorius.